Hello, welcome back. I'll be your host for this roundtable, which is devoted to the rule of law crisis in the European Union. We have two outstanding scholars as speakers. And let me start by introducing Professor Carlos Closa Montero. Carlos Closa is part-time professor at the School of Transnational Governance and professor at the Spanish National Research Council. Before joining the School of Transnational Governance, he was deputy director at the Centro de Estudios Políticos y Constitucionales in Madrid and a member of the Venice Commission. He wrote a lot on this and other topics. I would like to mention here an important book he edited on secession from a member state and withdrawal from the European Union. He also edited with Dmitry Kochenov an important volume on reinforcing rule of law oversight in the European Union, published by Cambridge University Press. So thanks indeed for joining us, Carlos. Ready where you are. Carlos, can you please check your mic? Here we go.
So we thought to put it in the cover. Now, we were thinking that after 2016, the book is from 2016, there was a lot of necessity to revise what we included in this book. Particularly, there have been many events from the political side and also from the institutional dimension. So these kind of events always give the opportunity to flesh out some of the ideas we have. And here I'm going to try to test some very rough ideas, and it's not necessarily the case that Dimitri and myself agree, and you will see that we have strong disagreements on certain points, and probably there will be a very good point to extract some robust conclusions. But let's see how the session goes. What I have done is to prepare a small presentation. I normally do this to clarify my own thoughts. It's not because really it's needed, but rather because I prefer to use a PowerPoint presentation to clarify my thoughts. So let me see whether I can show it to you. Okay, here it is. Can you see it?
Yes.
Okay. Thank you. So basically, I'm going to try to present an overview of the toolbox, the whole rule of law toolbox of the European Union, and try to debate some conclusions about what you have there. And I was following in the morning a little bit the presentation by Professor Teledone. So there is a little bit of an overlap, but not very much, because the kind of approach I'm going to take is slightly different. In any case, I think there are strong synergies between my own take on the first part of my presentation and what you saw in the morning with Professor Teledone presentation. Now, if we were going to speak about the toolbox that we have here in the European Union to deal with the rule of law, and I'm going to introduce the different elements in a moment, I think first we have to ponder the different analytical mechanisms that we can use to discuss them. And I try to single out these 5 mechanisms that I want to apply afterwards to the different instruments. And the first analytical dimension refers to the scope. What is the remit that the mechanisms cover? And you know that there are different reaches within the different mechanisms, and the scope can be specific when it addresses only specific breaches or values, or can be of a general character when it addresses all member states and not a specific breach. And that makes a very important difference. I'm going to try to argue that later on, but let's for the moment just retain this element of a scope. The second element here for the analytical construction of that is the trigger. Is the mechanism activated only when something happens? That means that it's an incidental mechanism, or is rather pre-established independently of any kind of accident or incident. So the European Union applies those instruments regardless what is the specific situation in any country or all of them. And that difference, I think, is particularly relevant also for other kind of questions I'm going to raise. Now, the third aspect, the third analytical aspect, is the effect. What kind of effects the different instruments have? And one of the possible effects is a preventive effect, ex ante effect, so trying to prevent that things go wrong, that the rule of law is breached by any member state, or else can be reactive. In fact, try to correct rule of law breaches, and hence is an ex post mechanism. Fourth element is the agency. Who are the institutions involved in activating the instrument, but also implementing it? Very simple. Basically, we'll be speaking here about 4 institutions: the triangle, the legislative triangle of the Commission, Parliament, and Council, plus the Court of Justice of the European Union. So it's the 4 issues we're interested in. And final aspect is the mechanism for compliance. And here we have a wide panoply of different mechanisms for obtaining compliance: dialogue, sanctions, ruling through adjudication, peer pressure, naming and shaming, and this is not exhaustive list. So there are other elements for compliance that can be adhered. Now, see, you retain these 5 elements. They compose a very nice grill to analyze now what is the whole set of tools for rule of law compliance, right? And here you have in the first column the whole set of instruments, and then you have the different characters that have different elements that have singled out for analytical purposes, right? So in 2 instruments, you have Article 7 discomposed in 2 parts, and I have indicated also the year in which they were created, and that's particularly important because institutions and instruments are designed against a specific background, and what we know in a certain moment perhaps is not valid later on, and that explains some of the inefficiencies and irregularities that you can identify in some of these instruments. For instance, Article 7 was first devised in 1996, and at that moment there was no evidence that backsliding could happen. So the very poor design of the institution, or you could say that it's not a poor design, you could also argue that it's a very intelligent design, but anyway, the design of the institution at the moment responded to the risk calculation that the states had in 96. So they didn't really think that backsliding could really happen. Then you have the Justice Scoreboard, the Rule of Law Framework in 2014, the annual Rule of Law Dialogue of the Council, infringement action, which is a general instrument. It's not specifically designed, it's the only one that's not specifically designed for rule of law, but nevertheless has been, as you know, highly important, highly relevant for controlling rule of law breaches. Then you have systemic infringement. This is not a specific instrument, and that's the reason I have put it here in a different color. But I know you were speaking in the morning about this. This is the proposal of Kinley, and for me, it's particularly important for heuristic purposes. So I would use it to discuss why I do not think it's a good idea, and because of the implications it has in institutional, but also in a more deeper way. Then you have the very recent rule of law review cycle that the Commission is implementing every year. And by the way, I know that the next cycle will change a little bit the composition of the items that are included there. So it's interesting to watch out what will be included, and I think the expansion will go in the direction of NGOs, media, civil society, freedom. So it will be a widening up of the traditional scope of other instruments. Then the recently approved regulation on funds conditionality that I think you also discussed a little bit in the morning. And finally, one thing which is not often mentioned, but I think is particularly relevant from the point of view of models, not so much in effectiveness, which is the cooperation verification mechanism that is implemented in 2 specific cases, Bulgaria and Romania. So this is the whole set of instruments. And what you have here is the composition of the different elements, which help us to understand how they function and some of the inefficiencies you can find there. Fair scope. And what you can see here is that there is a predominance of specific instruments over general ones. In a nutshell, what I am saying is that the European Union has designed instruments to target or to contain specific breaches. There are instruments that are general to guarantee the rule of law across the Union in general terms. Right. Some of them have emerged in the last years, and particularly I think perhaps the most significant one is the review cycle of the Commission. I think it's a particularly robust general instrument, but there is a strong predominance of specific instruments targeting offenders. But next to this, you have the trigger, what triggers, what activates any of the instruments. And again, here what you have is a strong predominance of incidental instruments. What does it mean? That something has to happen for those instruments to activate it. And you combine these two characteristics, a certain pictures starts to emerge, right? Specific and incidental means that in a way, the scrutiny of the rule of law in a predominant way is perceived by the European Union as a kind of incidental specific event in the European Union. It's not considered as something structural. So there is not a content of a structural instrument there. Now, the third element, is the effect. And here what you have is a nice balance, I would say. It's a nice balance between instruments who have got a kind of preventive component, but also quite a few with a reactive component linked to enforcement. I am going to say something about enforcement because I think that we have a strong problem here. And fourth, the actors involved. In most cases, the panoply of actors is very much concentrated on the Commission. And as you can see, the Commission is the actor everywhere apart from the rule of law dialogue. And that means that the whole system of rule of law scrutiny and monitoring in the European Union is tilted towards the Commission. That's as a result of the design. And then, paradoxically, Council member states are not that prominent as actors here. And as you can see, the European Court of Justice is fairly residual. Residually only appears in connection to the infringement actions, and of course in the proposal of the systemic infringement action, which is a kind of derived element. And finally, the fifth element here, mechanism for compliance. And here is what I said before. You have a huge variety of mechanisms for compliance. Article 7.1, purely speaking, only introduces dialogue and peer pressure. So you could read this very easily. Specific breaches by specific states trigger preventive action with only channels, dialogue, and peer pressure. That will be the kind of horizontal reading of each of these instruments that will give you a sense of purpose. Now, what I want to underline here is that there are very few elements that got very strong, very few instruments that got a strong compliance mechanism. You have sanctions, eventual sanctions, not real sanctions, because this is opening in the wording of Article 7.2, associated with this particular instrument. But in the other cases, what you have, you look at them, is basically very soft mechanism. Even here, when you have rulings, rulings are not necessarily sanctions. And that creates an important point that I want to discuss, right? So you may have a ruling that indicates you have to do something, but only if there is a persistent non-compliance with the ruling, then sanctions will be activated. But it's not automatic a result of rulings. And that tells in a nutshell that the mechanism for compliance, the whole set of mechanisms for compliance, in a way within the European Union toolbox for rule of law, relies heavily on mechanisms which are, so to say, soft compliance mechanisms. So this is a very quick overview, and I don't want to go more in detail because I know that you have been talking about this in the morning and you have already knowledge about that. So just retain this general idea, a huge number of tools with different scope, different trigger, different effects, different outcomes involved, and above all, different compliance mechanisms. Now, how efficient are the tools? What is the kind of evaluation, review, assessment we can do about the tools? And here I divided them in two parts, the preventive measures, the preventive instruments, and the more specific one. And looking at the actions of the European Union in the last, probably the last 7 years, starting 2013, 2012, perhaps, 9 years, the balance is not particularly relevant. If we look at general measures, which are the justice scoreboard, the rule of life cycle, what you have there is that they are very useful in providing information and reporting with some adaptation from member states. And paradoxically, I would say that one of the most interesting effects of the rule of law cycle has got something to do with anticipatory effects that has had in some countries, and particularly in the case of my own country, in Spain, in which the Commission has put the spotlight on the regulation of the Spanish Judicial Council, that the way is normally quoted in Poland as the model that has been followed to implement the model of the Judicial Council in Poland. Now, the Commission in the report, into 2020 report, the Commission recommended that some adaptations had to be done in Spain in relation to the Judicial Council, and this has triggered a lively debate and a political controversy in the country, which I find it very useful. So what I will say here is that the paradox that these Commission general measures are particularly relevant for information reporting purposes and particularly useful in cases in which there are not huge rule of law crises. So you have this paradox. Introducing general measures are useful for policing rule of law in situations where you don't have a crisis. And I wouldn't downplay this. This is a particularly important result because it speaks of the anticipative value of introducing this kind of general measures. What are the effects of the Commission-led specific measures, rule of law framework, Article 7? They have served to put significant pressure, particularly in Poland, a little bit also on Hungary, although Hungary has sailed in a much more efficient way through this kind of mechanism. But as you know, no significant change of political course. So the kind of backsliding policies have been implemented regardless of these Commission-led specific measures. And something happened, something similar with when the European Parliament took the lead, in particular Article 7.1 against pressure, again, political pressure, but no significant effects. And here the Council majorities invoke as a kind of explanation. And finally, the last of the preventive measures, the rule of law dialogue, I think most of the people working on the area, most of the authors working on the area will agree that it's a totally useless strategy or useless initiative, has not been any kind of result, and something could be scrapped and no one will be crying in the corners or in the corridors because it hasn't brought any good. Regarding what they say, I would like to emphasize that these general kind of measures with a preventive character are very good to anticipate problems all across the European Union. And also, I think they are very important to anticipate some of the criticism. One of the criticisms that was originally voiced in relation to the more incidental and specific measures was the asymmetrical treatment for Western and Central and Eastern European countries, which I think is a fair criticism. So some governments in Central and Eastern European countries voiced very loudly their complaint that the Commission treated them differently, and countries in western part of the continent were not subject to the same kind of scrutiny that they were put under by the Commission in the case of countries like Hungary and Poland. And I think it was a very fair criticism. And in a way, this kind of general measures diffuse this kind of criticism and increases the legitimacy of the actions to scrutinize rule of law compliance. Now, what can we say about enforcement or reactive measures? It is true that the infringement actions have produced some results. You have, I think you have spoken about this in the morning, so I'm going to expand more my intervention here. The case of judges in Hungary and Poland. But I would like to introduce here a caveat because there is a wonderful paper by Agnes Bathory in which she speaks very eloquently about how Hungary has rhetorically and symbolically comply with the rulings, but not really in substance. So this is an argument which is very well known. You can comply informally with the rulings, but not necessarily change the substance of the policy. And this is basically what is happening in a way with everything that is happening with the infringement actions. And that in a way grounds one of my skepticism with this technical infringement procedure, right? That I will come back to that later. Now, a more recent element in this enforcement set of tools refers to fund conditionality, which has been untested. And there are some skeptical views. For instance, Logan Page has been very skeptical and very critical. I am perhaps much more positive about the regulation, perhaps because I speak to the person in Jourova's cabinet who is monitoring this instrument, and I know a little bit their mind, and despite the fact that some people are criticizing the delay of 1 year that will be introduced by this Hungarian police authorities case in front of the European Court of Justice. The Commission is arguing, of course, they haven't made public this argument, but they are arguing that preparing a case for breaching funds conditionality takes a lot of time. And what they are doing is use the time to prepare the case. So in the moment that the court clears the regulation, they could activate immediately a case against offending countries. And apparently, there is determination in the Commission to move in that direction. But truly speaking, this is an untested mechanism, and it's a mechanism, we should underline that very much relies on one particular instance, which is funds conditionality. Now, I very much think, before I was a little bit skeptical about the importance of fund conditionality, but lately I've been more convinced on that, particularly following a little bit Dan Closeman argument about the importance of European Union funding for, in a way, verifying the working of these semi-democratic governments in some countries, right? So apparently European funds are particularly important for keeping them in power. So if that's the case, having this kind of instrument could be fairly instrumental to stop the situation. And finally, you have Article 7.2, which is so far untested and probably will remain untested because the unanimity requirements. Although I do not think that unanimity is the whole explanation about that, and I'm going to come to this in a second. So in a way, how efficient are the tools? Very little, with the exception that they can be used in a preventive way across the Union to anticipate problems whenever there is a crisis of the rule of law. So it's a kind of very paradoxical conclusion I will raise here. What are the key lessons that we can learn about those tools in the last 9 to 10 years? I think I would be in the safe side if I argue that there is a lack of efficacy of each tool separately. But I would also say, and I don't want to make a very strong claim, just a very soft claim. So everything we can say here is slightly relative if we try to value that cumulatively, these instruments serve to improve the quality of the rule of law in the absence of rule of law crisis. So I again emphasize this paradox. We have created an environment to reinforce the rule of law crisis, provided there is no, to reinforce the rule of law, provided there is not a crisis of the rule. And why is so? What explains this lack of efficacy of each tool separately? I think there are two explanations. One is institutionally driven. One is looking at what institutions that. And here is something I have explored in a recent paper, but it's a paper that connects also the previous writing by Ulis Edelmeyer, but Dan Closeman, by Kim Lane, and others on the issue, and focuses on the role that institutions play. And basically, the argument would be that each of the three institutions that are involved in the different procedures, leaving aside the court, each of the three institutions follow different and non-coincidental logical actions. So the Commission has a strong preference for dialogue, and this has been strongly criticized. Many people say why the Commission is not does not pursue in a stronger way, forcing compliance for breaching states. And one thing I found out talking to officers in the Commission, the ones who are in charge of this kind of dossiers, is this idea that they prefer dialogue. They prefer dialogue as a mechanism for compliance. And they always underline that the objective is to reverse behavior, not to punish, to obtain compliance, not to put a penalty or a fee. What is the final objective for them is to reverse behavior. So whatever is suited to do that will be preferred. And in their view, dialogue, engaging with national authorities work much better than a confrontational situation that takes you to a clash with national authorities. You might disagree with that, but what you cannot say is that there is no certain kind of rationale in the way the Commission constructs its own position. And by the way, don't forget that the kind of attitude that the European Commission follows in the situation in which it's looking at rule of law, which is very similar to the situation that the position that the Commission takes when it's looking at competition policy, for instance. Engagement, dialogue with national authorities, always comes first, and the Commission seeks to diffuse as much as possible action in front, for instance, the European Court of Justice. And also the Commission is very adamant of an additional problem here, which is the dilemma of enforcement, right? So how to pass from Article 7.1 to Article 7.2. And the question that the Commission always has in mind is whether the Council will support an activation of Article 7.2. And the Commission says, if the Council does not support us, then the authority of the Commission as the one guarding the treaties will be seriously undermined, because the other institution is not supporting your initial perception that treaties have been violated, right? And that will undermine the whole system, not specifically the rule of law scrutiny mechanism, but the whole system. So this kind of precautionary approach of the Commission, you might disagree, but certainly could not be said that is lacking rationality, lacking foundation. Then the European Parliament follows what Uli Selmayr very nicely has characterized already in 2012 as the logical partisanship. Has been really explored a lot, and you have heard about that. Parties protect those who belong to the same family, so we don't need really to delve a lot into that. And then finally, the council follows a logic of collective action under unanimity. And I think a lot of emphasis have been put on the mutual protection of Hungary to Poland and Poland to Hungary. But in the behavior of the Council, there are always additional complexities, right? And by definition, governments are not prepared to sanction their peers unless there is a significant cost for not doing so. And if you want to take as a proxy for that, as an example for that, look at what is happening with the Stability and Growth Pact. Under the Stability and Growth Pact, governments can denounce each other for failing to comply with the obligation, and that has not happened ever. Well, there is one case, but in the almost 20 years that the pact has been there, has not happened ever, despite of systematic breaches by many countries of the Stability and Growth Pact. And the amount of externalities in the case of the pact, the amount of effects that a country can transfer to others in the case of the Stability Pact is much larger that can happen under the rule of law regime. So in a nutshell, governments are very reluctant to act. And if you follow, and I have done a tracking of the positions of the governments from around 2013, 2019, there were not that many governments who were particularly eager to engage those who were perceived as errant governments. Of course, this number has increased across time, but initially only 4 or 5 countries were in that very strong position. And some others, and I can quote here my own country, Spain, the Spanish government was very reluctant because they fear the political effects of activity in such a strong mechanism, how it could be reversed to act in the domestic scene. And that was felt also in other cases that perhaps we can discuss afterward. And finally, there is the fourth institution, bringing in the court. And as I said before, this is the favorite solution put forward by King Lane Shepley, which I have 2 important objections to do here. The first is that building up the notion of systemic infringement requires a lot of creative thinking that we as scholars can do. We as academics can identify what a systemic infringement action is. But for a court to act on those bases will be very similar to create a kind of what has been called in some areas as a kind of general cause against a certain country, because you have to put together things that respond to breaches against different treaty provisions and give them a sense of purpose, which is the more difficult thing in the way that those different breaches serve to the general purpose of undermining rule of law. This requires very sophisticated theoretical thinking that the main trigger here, the institution triggering this action, but that is the Commission, is certainly not prepared to do. And I have doubts whether there will be a free-flow avenue. But the second thing, the second objection, which I think is much more relevant, and is the one I really be very reluctant to give away or to consider can be simply dismissed, that even though the Court of Justice of the European Union can certainly adjudicate in a streaming infringement action in terms of capacity, in terms of intellectual rights, in terms of, I doubt it, in a sense. I don't think in terms of competence, in terms of power, that will be the adequate thing to do. Why? Because some of these rule of law breaches affect a fundamental element of constitutional structure, domestic constitutional structure, which is check and balance, separation of powers. So the actions of certain governments are basically undermining the independence of the judiciary. Now, it's certainly true that constitutional courts should intervene to adjudicate in this kind of situation, but it's more dubious whether you can have a supranational court adjudicating on domestic issues pertaining check and balances. Certainly, I would be in favor to doing that, but my point here is that under the current treaties, that will be a move that goes really to the border of the powers and competence of the court, and I would say even is beyond the treaties. And certainly, that could be something to be done in the future, but that will require a revision of the treaties that says specifically so and empowers the court to act in a much more meta-constitutional role, adjudicated internally. There is a precedent of that, if you want to illustrate the case, because normally in Europe we consider we are the first to do that, but if you look at the role of the Central American Court of Justice, which is probably one of the less legitimated courts, supranational courts in the world, intervene more than once, but in a particular case, very intensively, in a dispute between the president and the parliament of Nicaragua, adjudicating that case, and adjudicated in favor of the parliament, and the ruling of the court was simply ignored domestically in Nicaragua. That says something about the risk of playing this kind of institutional game. I'm particularly skeptical about this kind of solution. I know that Dimitri is perhaps a little bit more in favor, and probably he's already hearing me and noting a lot of objections and willing to criticize. So this is the first explanation, institutionally responsible. But then I think there are more important substantive explanations to why rule of law instruments have been inefficient so far. And they go to the very nature of the European Union. Basically, the European Union is a community of law in which implementation compliance depends on states' adherence to the respecting the rule of law. And that creates a catch-22 situation, which I will put to you with a single question. Why would a state that disregards rule of law will comply with the law emanating from the European Union? So if you don't want to comply with the law, why would you comply with rulings, recommendations, regulations, and so on and so forth? That creates a catch-22 situation. And I think this has a lot to do with the last point I want to make here before moving to conclusion, is that in a way, the problem to guarantee compliance with the rule of law when there are breaches is that the European Union, being a community of law, lacks coercion, the coercion which is normally associated with enforcement. And if I can draw a very provocative parallelism with something that's happening in Spain, if you have followed events a few years ago in Spain, when you have this secession crisis in Catalonia, this crisis was presented as a kind of opposition between democracy on the one hand and rule of law on the other, being democracy, the prohibitionist camp, and rule of law, the Spanish authorities. I don't want to enter very much in the substance of that, but I want to tell you the following. Rule of law at the end prevailed, or the Spanish authorities could impose rule of law just because they had coercion, physical coercion on their side, meaning police authorities. I know I'm bringing here a very controversial and radical comparison, but it's for the sake of illustrating how compliance in a community of law lacking coercion rests on the willingness of those who paradoxically breach or break with the law. And that creates a very difficult situation that could explain why this is happening for the last 10 years. Now, I want to move very quickly to some conclusions before giving the floor to Giuseppe and Dimitri. and which is not a very optimistic line. It's how far can backsliding go? And here I will invite you to put yourself under the lenses of unpredictability. You've been talking here about rule of law, you've been talking about Brexit, and if you were going backwards, say year 2016, year 2015, and I was going to ask you, do you think the United Kingdom could leave the European Union? Say, nah. Do you think there will be a president in the United States that will be absolutely populist? You say, no way, and so on and so forth. My invitation here is to think that the unpredictable can happen. So it's not that we are at the end of the backsliding. Something worse could happen. So we shouldn't really rule out on that. And if that can happen, then in the absence of enforcement to contain authoritarian reversals, suspension of membership may become the last action for protecting the rule of law and democracy. Not only for the sake of those who are breaking the rule of law, but also for the sake of the current members. But this, of course, requires the change by unanimity, which is a kind of no-go area. So we have a kind of catch-22 situation. And with this very optimistic line, I conclude, and I will look into to hear your questions and happy to respond to them. Thank you, Giuseppe. Thank you.
Thanks indeed, Carlos, for this very rich presentation, which is really an added value to this day devoted to the rule of law crisis. Now I immediately give the floor to Professor Kochenov, just 2 minutes to say a couple of things about his very brilliant CV. He's a professor of law at the Central European University in Budapest and Vienna. He recently moved there. Prior to joining the CEU, he was a professor at the University of Groningen in the Netherlands. He has held visiting research and teaching appointments in many leading centers, including Princeton, NYU, Boston, Louis Docali, Rome. And he has written extensively on censorship. His book on censorship has been translated into different languages. There is also an Italian version published by Il Mulino. But he also covers, of course, the rule of law issue. And apart from the book edited with Carlos, he also edited another important volume with Andras Jakab, entitled The Enforcement of EU Law and Values. So he is another great expert of the topic. Having said that, Dimitri, you have the floor. Thank you very much for joining us.
What a delight and honor to be in Pisa again. Mi piace tantissimo Sant'Anna. It's an amazing collective of leading scholars. And in particular, I'm delighted to speak after Carlos. Last time we had such a gig, it was at the Venice Commission for Democracy Through Law, where we presented the volume. And I still remember vividly how the Hungarian representative started shouting, telling us all the problems emanate from you scholars, because you pretend that rule of law has a meaning. And in fact, as a constitutional court justice, I know that it doesn't. And it was a very interesting and informative event. But let me pick up where Carlos left it. Actually agreeing with Carlos on almost everything he has said, but then twist it in another way, because so far the literature has been focusing on why the enforcement of the rule of law doesn't work, presuming that we are only faced with one problem and one interest. And that problem is backsliding in Hungary, backsliding in Poland, probably other countries, and then the EU doing its best to deal with this kind of backsliding, which is of course poisoning the very fabric of our constitutional system. And what I would like to suggest is that there is a second side to this coin, which should also be taken into account. And that is the interest of the Union as such in adopting a more assertive position vis-à-vis the member states and building its own constitutional system, probably at the expense of the member states, which is to say that although the story can be presented as generally a failure story, if not a catch-22 failure, then just a failure. And on this I agree with Carlos. It can also be presented as an overwhelming success. And my focus will be on the overwhelming success part of the story. And then I will ask the question, success for whom? Because it's obvious that the European Union has significantly consolidated its ability to interfere basically with the rule of law matters at the national constitutional level in all the member states. So the crisis has been successfully deployed and successfully utilized by the Court of Justice in order to significantly, and if not actually overwhelmingly, increase its own scope of competence in terms of interference with national constitutional affairs. I say interference because of course it's welcome since it's a crisis. Given what's going on in Hungary and Poland, there will be not a single person in France, the Netherlands, or Denmark shouting that the EU should stay away. But what we see is a radical reinterpretation of the law, which is akin to the reinvention of the system. Because if you read Article 19, which is the main trigger in the whole story, and I will remind you of the whole story in 1 second, you will see that the article basically says, well, all the courts of the member states are EU courts, full stop. And then we presume that those courts are independent. We presume that those courts are benevolent in terms of applying the right law, and that they will be receptive to what the Court of Justice thinks the right law is. So the Court of Justice is then on top of this pyramid, and Article 19 has been there from the first steps of the baby communities. So Article 19 has not changed since the end of the 50s. Since the end of the 50s, all these courts were supposed to work together. Since the end of the 50s, the national courts were the branch of European judiciary. And since the end of the 50s, there was this understanding that they will be speaking to each other. What we didn't see from the end of the 50s is the interpretation of this provision that would allow the Court of Justice to come to the national level and to tell the member states how they should organize those courts and how the member states should interpret the principles which underlie the basic structuring of their institutions. This is absolutely new, and this dates back to 2018. So in 2018, of course, at the high point of the crisis, terrible things happening in Poland and Hungary, up to the level of the Polish government openly disregarding and actually being vocal about it, disregarding the rulings of the Court of Justice. The Court of Justice tells us, well, and this is the most important development that all my perspective rotates around. The Court of Justice tells us, well, Article 19 speaks about these national courts, which are EU courts, so it's obvious that European values apply to those, and that we can check to what degree European values actually do guide the establishment of the local judiciaries and the functioning of the local courts in the member states. So after, let me count, after basically more than 60 years of interpreting this clear provision in one way, the court tells us nothing has actually happened. We took this classical article and then it interprets it in a radically different way. Who is the beneficiary of this? Of course, officially, and that's a very sound starting point, the court is doing its best in order to solve the crisis of the rule of law in the member states. So the beneficiaries of this U-turn in the understanding of Article 19, and I invite you all to read Article 19, you will see that, well, it's like Commerce Clause in the US. You can inflate it, but you can also deflate it. So the beneficiaries are stated to be the member states. Yet, we've heard from Carlos, I fully agree, nothing has changed in the member states. There has been no improvement in Poland at all. In fact, the situation is much worse because now the judiciary is split roughly 50-50. Some say we honor what the Court of Justice say, others say we don't actually honor what the Court of Justice say because we are national judges, or there is a third category, those who try to be in between. The trouble is the perspectives are irreconcilable. So we see the Supreme Court trying to adhere to, at least some judges, trying to adhere to the European Court of Justice position, which is solid, which is valuable, and which is important for us. But at the same time, the Constitutional Tribunal in Poland is overruling those guys, saying that in fact this is not what the law in Poland requires them to do. And what interests me here is not the Polish conflict as such, but the absolute anarchy on the ground at the level of the judiciaries, which has been created by their interpretation of Article 19. And this anarchy is not there. I'm not criticizing the Court of Justice for grabbing power in a way. This is something that the court had to do, and it had great intentions. But the court had to envisage that the situation that we're facing on the ground in Poland and in Hungary now will be exactly the outcome. And the outcome, the predictable outcome, is that of the destruction of any trust in the judiciary as a concept, not only as a set of institutions, in those states where precisely we need those judges in order to save at least something, what remains of the rule of law. So the stated goal of helping the Hungarians and helping the Poles to safeguard and rebuild the state as a democratic rule of law state doesn't work, because this is not what the European Union has achieved, and this is not what the Court of Justice has achieved. Then what has worked? Well, the Union is building its own constitutional system. Its own constitutional system needs to be based on clear principles and clear values and clear rules, as well as the ability to claim the ability to govern. And this is something that the Court of Justice has abundantly created on the basis of the crisis. So it's the most natural move. If you are in the position of power and you honestly and wholeheartedly believe in the need to reinforce your institution, which you see as an emanation of justice in Europe, this is what you do. There was an opening, and the Court of Justice has used this opening in order to significantly reinforce its own position and in order to reinterpret the very basis of European constitutionalism. Because before, all these values, before 2018, mind you, all these values, what we read in Article 2, they were mere proclamations. There was no direct way of enforcing them for all the reasons that Carlos has just explained. And suddenly we get a totally different picture as a result of this crisis. So my point is a very basic one, the starting point, and that is the Court of Justice is one of the main beneficiaries of what is going on, and there are plenty of reasons behind what is going on, which are not stated reasons. So the Court of Justice and the Union as such have been failing if assessed against the standard checklist of the stated reasons of what they want to achieve. Different Poland, different Hungary, stronger rule of law in the member states. All that is empty talk as it stands, as the Union stands. But the European Union has overwhelmingly succeeded in reinforcing its own legal position as a community of law in a new, abundantly important sphere, which is the rule of law and potentially other values. Because Article 19 obviously can be connected to other features of Article 2, which is the list of the values of the Union. So this is my pessimistic, optimistic view. In fact, in order to achieve success at the supranational level, when approached from the point of view that I'm suggesting, we do not need to book any successes at the national level, because the very attempt to move and to actively engage with the judiciaries and other institutions, essentially the separation of powers at the national level in a forceful way, is in itself already a huge success for the system of law, which is the European Union, for the supranational level. So this is point number one. Point number two, all this comes at a huge cost, because whatever we think about Weiler's arguments concerning throwing stones in a glass house, the EU being the democracy glass house, those arguments might have a point to them, which is the member states, at least as proclaimed, are robust democracies based on the rule of law and based on the clear understanding of the importance of separation of powers. In the EU, we didn't have the rule of law until 2018, although of course there are all these judgments, Lever, etc. If you read classical doctrine, Lord Mackenzie Stewart, Maria Luisa Fernandez Esteban, there are plenty of great writings, but they tell us one thing: the rule of law in the EU means that the EU acts in accordance with the law. We are not philosophers, but we can still see a circular argument, because the law is what the union creates for itself. Which means that if we take this understanding and apply it suddenly to the Hungarian government of Mr. Orban does have a rule of law. And it will not be a surprise at all, because he doesn't breach his own constitution, he simply rewrites it. And he rewrites it in accordance with what the constitution demands of him in terms of the procedural requirements. So then it's clear that this kind of understanding of the rule of law is flawed. So for our purposes, it's unusable. It's something that we should not take as a starting point, because we don't want the union to have the understanding of the rule of law guiding it, which overlaps 100% with the understanding of the rule of law, which guides Prime Minister Orban, whom the union then is criticizing. It means that the rule of law should be something different. And here I think that one of the most important contributions in Europe in terms of trying to understand what that difference should be comes from Sant'Anna precisely, and that's why I think it's a huge honor for all of us to be there, even if only virtually. That's Professor Palombella, who connects contemporary understanding of the rule of law, including the contemporary leading philosophers of the rule of law, like Martin Krieger, with the medieval understandings. That is, the rule of law that predates democracy, the rule of law that predates the idea of human rights, the rule of law that has a significance of its own. And if you remember leading Americans writing about the rule of law, well, it makes no sense to write about a concept if you don't believe that this concept has a meaning to itself, which is distinguishable from any other concept around it. So if you say democracy is not separable from the rule of law, it means that you don't believe that rule of law is a concept worth studying. And then if you disagree with that position, and that would be right, then you need probably to look at the situations where the rule of law can be dissected in a way that does not mingle it together with other concepts. Also the ones that we find in Article 2. So what Palombella finds and what Krieger supports, and what I think would work for us, is a rule of law which is not only circular in terms of being able to act in accordance with the law, because then the European Union is indistinguishable from Mr. Orban, but a rule of law which supports a conflict between the law that is authorized by contemporary democratic leaders, or whoever is in charge as a sovereign, and some other norms. So what Palombello calls gubernaculum versus jurisdictio. It means that the sovereign is always, even the democratic sovereign will, if you want, is always necessarily constrained by some kind of external force, which is also law. And the conflict between these two is where the rule of law emerges. So the rule of law is standing on the way of unlimited exercise of power by the legitimate sovereign, which means that the rule of law is always in contradiction with, or it is always in conflict with absolute democracy, because absolute democracy, absolute sovereign domination is something that any mature legal system precisely wants to avoid. And this is where we see populism as an emanation of something that is in direct conflict with the rule of law. So democracy is never an answer when the rule of law is the problem. And this is good news for the European Union, because the European Union is not a democracy. So what we look at when we look at the European Union standards and European Union tools is these are all valid, these are all legitimate starting points of thinking about reinforcement and upholding the rule of law. So this is where I come, the perspective from which I come to disagree with Weiler. So whether you throw your stones in a glass house or not, for the rule of law it doesn't matter. So you cannot criticize the union for the engagement with the rule of law because it's not a democracy. But, and here I make my third point, it might be that the EU actually does have a problem with the rule of law. And that problem will be the absence of this clear divide and conflict between gubernaculum and jurisdictio. Because if you look at all the recent case law of the Court of Justice, including the deployment of Article 19 in all the recent rule of law cases, you will easily see that the union's starting perspective is precisely to use the rule of law as a trump card to claim supremacy over EU law. And when you say our rule of law means that we are supreme no matter what, then it's basically saying, well, our system is not based on the principle of the rule of law. And the Court of Justice has deployed it to different levels in plenty of different cases. So if you remember CADI, where it scrutinized international law against own principles, now this is perfectly just and this is perfectly fair. But this is an example that the European Union is not constrained by international law. If you remember Opinion 213, where the Court of Justice refused to give a blessing to the European Union to join the European Convention on Human Rights, that's another example. It shows that if human rights of own citizens could potentially undermine the leading position of the Court of Justice and its ability to use the rule of law principle as a trump card for supremacy over EU law, then we will not have human rights for our citizens. And there are plenty of problematic paragraphs there. So, and the same applies to national authority. If the Bundesverfassungsgericht disagrees, then we all laugh at the Bundesverfassungsgericht because that's against the principle of supremacy of EU law. But then where is the check? And on the basis of what, rationally speaking, what kind of ideas can you invoke in order to disagree with this circular understanding of the rule of law? And here we're in trouble because obviously the EU not being a democracy, it doesn't generate any kind of source of democratic legitimacy that could counterbalance the strict interpretation of the internal market in its broadest sense, including monetary constraints and now introduced into the national constitutions, including the idea that free movement across borders can get fetishized and overemphasized at the expense of probably other important values in our societies. So plenty of problems arise. And to finish, I think the most important take-home lesson from my view of the crisis that I wanted you to see is that very much depends on taking the non-stated reasons into account when we speak about the rule of law. And the non-stated reasons always include the institutional perspectives of all the actors involved, which means that the Commission can have a fundamental interest in being weak. And the Court of Justice will have a fundamental interest in this U-turn of Article 19. And the Council has a fundamental interest of never taking Article 7 seriously. We can discuss it in the Q&A. So then a slightly different picture emerges. And in this picture, there is one winner. And that winner is the imperfect European Union, which suddenly became a world-leading rule of law actor without necessarily itself complying with the rule of law, which would be different from what Orban has in his the mild dictatorship of Hungary. And this opens a Pandora's box. So we could speak about it in the discussion. So thank you very much, and I apologize if I went over time.
Thanks indeed, Dimitri. Fantastic, superb. So we have now 24 minutes for questions and comments. So I would suggest we should collect some questions and comments, and then we will have different rounds of answers from our speakers. Okay, so any questions, comments? Yes, I see Francesco Faieta.
Yes, I've taken inspiration from a question of Adam that I think he made yesterday. He said that maybe the Brexit was something that adds something positive, for the future cohesion of the European Union. So I am a little bit provocative, if maybe one day Poland or Hungarian will go out from the EU, maybe it will have some positive effects on our cohesion. Maybe we can make stricter rules, and we can be more democratic in that union. That's my question.
Thank you, Francesco. Any other questions or comments? Yes, I see Adam, please.
Yes, I had very similar thoughts, by the way. It was my first reflex was it'll be better if they just weren't around. But I have an observation about rule of law and my understanding of it, because I'm not completely sure if I have grasped it. I think I maybe have a conservative perspective of rule of law. In my mind, rule of law means that the law, like as a principle, usually in a constitution, but not always, is what rules in the end. So the rulers themselves aren't the ones that are in charge. And I think that when you're discussing it with the European Union, the strong thing that comes to my mind is whether or not we can even discuss this concept in the European context, because it's based on treaties, first off, which are international instruments, which puts it in a different sort of realm, in the realm of international law. And I don't think that there's really rule of law on that level in the same manner. So I'm just a bit confused as to your terms and the way that we're defining it, and if that's a good way to look at it. I mean, if the European Union can't coerce Hungary and tell them what to do, or can't coerce its subjects, then the law can't rule. In my mind, ruling implies a necessary coercive power in order to even exist. So I'm curious as to if I maybe have a flawed conception or if there's different views.
Thanks, Adam. Now, Matteo.
Thanks. I'm very interested in the presentation of the Professor Kochenov because in his third point, I have thinking about the Taricco saga in Italy because it could be an example of the building of a European rule of law, because if it was never explicit, the result was the was a commitment between the Italian Constitutional Court and is in a very simplified way. I don't. Is a problem. Is a very problematic case, but I have this thought about your third point.
Thank you, Gurkan.
I want to mention something about Professor Carlos' argument about Kimberley Chappell's institutional analysis. I agree that institutional analysis or this kind of analysis is really hard for courts because it may lead to judicial activism. It is very dangerous. It may give rise to some political backlash. I totally agree. And it's really hard for courts to make a holistic analysis. And for me, the only successful attempt is the Colombia Constitutional Court's second re-election cases in that aspect, because when it comes to first re-election cases in 2006, courts abstained from finding the constitutional amendment unconstitutional. But when it comes to 2010, the second constitutional amendment attempting to extend the presidential term for the second time, the court step up and say that, oh, this is unconstitutional, you cannot do that. And I think this is a holistic approach. This was a holistic approach. And I think that yes, it is really hard to make this kind of an assessment, and it is really rare for courts to step up at the right time. I think the courts should try to do that, because I think the negative consequences of judicial restraint at that time of at this critical juncture is really huge, and there is no turn back in some sense. Because of that, for example, Colombia Constitutional Court do the right thing in some sense, and now Colombia in some sense a country of rule of law. But when we just look at other countries, Venezuela and other Latin American countries, we all just see success. What I try to say, the judicial activism can be compensated in the long term, but judicial restraint at this critical juncture is really hard to compensate, because judiciary is the last stop in some sense. That's why I think this also goes to the Professor Dimitri Kochenov's argument. Court of Justice, of course, it expands its scope. It's right. The competence of the EU expanded, and EU, in some sense, extended its competences against member states. And Court of Justice is the most successful in this sense. But there is nothing to do. At least at that time, especially when it comes to Hungary and Poland, I think this is the right thing to do, to force. Of course, you cannot defend the same argument when it comes to Germany and PSP, because Germany is a country of rule of law. You cannot blame Germany again. You are just extending your own competences. It will not be, of course, the right thing. But when it comes to the countries that is obvious breaches, of course, the court should enforce its competences. Thank you.
Thank you, Gurkan. I don't see other hands up, so I would suggest we should start with the first round of answers. Carlos first, I would suggest, and then Dimitri. Carlos.
Okay, thank you. Excellent question. So I think I will take the question of Francesco, Adam, and Gurkan, because I think Matteo was very specifically addressed to Dimitri. So Francesco was making the case whether the exit of Poland and Hungary would at the end to be a good thing for the European Union, because it will increase, so to say, cohesion. And I tend to disagree. I mean, the exit of any country for the European Union in a way marks a certain failure. I don't think it's that much the case with the United Kingdom, but certainly if ever Poland or Hungary were to leave the European Union, would mark a certain failure of the European Union. Why? Because we fail to socialize certain values that we believe that are really superior values, rule of law, democracy, fundamental rights, whatever. And you can disagree, there is margin to disagree how this has to be interpreted or implemented, but certainly if a country comes to the point of leaving the European Union, even if you win in terms of consistency, you lose in terms of really being persuasive with your own values. And hence I conceive the exit option or the expulsion option more like a kind of protection for ourselves. So try to imagine that the European Union is, in a way, is a powerless organization when it comes to the most extreme situations, right? So when I invite you to think on the unthinkable, try to think that a country can go all the way in an authoritarian direction, even to the point to reach a kind of semi-totalitarian situation. And if that situation ever arrives, the question for us is, can we live together with this kind of country? Try to imagine whether we could really accept a country like, I mean, there's strong comparisons, but the situation we had in Europe after the First World War, there were certain countries who were Jewish democracy. So would you be prepared to accept that our club should also integrate those countries for the sake of trying to socialize them? And my response is a negative one, but just because of self-protection reason, no, because of increasing our homogeneity. For Adam, which Adam, you raised questions which are really profound, and one of them has to do with the nature of international law to impose obligations. So it goes much beyond this talk, and it's something that Wilder touches upon in the chapter we have in our book, because that's a very critical standpoint towards that, but I will come back to that. But first, let me respond to Gorkan, because I want to rescue something in the response to afterwards come back to you. I don't know the case of Colombia Constitutional Court that you were mentioning, and I will be very cautious to draw analogies with the national level, because judicial activism in the framework of a treaty is not the same that judicial activism in the framework of a constitution, whatever nuances you want to introduce, right? So I don't think a constitutional court is fully equal to the European Court of Justice of the European Union. And even though I will agree with you with the fact that courts should be cautious, and perhaps I have here a much more political scientist approach to that, and I have doubts how much courts can achieve really by just ruling. So politics is a matter of power and a matter of relations. So courts certainly play a role into that, but reach certain point, then other factors are at play there. But in the context of the European Union, I would say that the point here is not so much putting the whole emphasis on the core system. Is there are other mechanisms there, right? And perhaps one of the things we failed in the past, we didn't fail that much, to be honest with you. We didn't fail that much. But if I can use the example you were putting of Colombia, which is this idea of extending presidential mandates, there was another country in South America who did the same, which was Peru, and Peru requested an opinion from the Venice Commission, who identify standards from the extension of the mandates of the presidents in presidential system. So this is an approach that is generally followed in Europe and was followed in Europe for those countries acceding to the European Union, trying to identify transnational standards for constitution making that could really frame the way you set certain rules. And that's perhaps what has been failing now, that this kind of procedure that we follow in the past was followed in the past with constitution making in Central Eastern European countries, now has come to some kind of crisis. So can courts repair that? I think again that this is something that happens because of circumstances and causes that are beyond the reach of the court. And certainly now there is a lot of talk on the importance that has to have a very strong civil society, actors who are empowered to litigate, to be complaining, to activate protests, because in the absence of that, if you rely purely on the judiciary, it is doubtful that you can really go beyond that. I don't know whether it's a good response to you. It's certainly a response, but the analogy is complicated between the national and the domestic level. And for Adam, as I said, there is a profound question here about how much an obligation can international law apply and how much an obligation can European Union law apply. But I'm certainly in the position of arguing that since member states upset European Union law, and they have said that in many occasions with some kind of constitutional adaptation, hence they become some kind of monist orders, and hence they accept themselves voluntarily the obligation. So yes, this obligation can be imposed. In that respect, I move in a different position to Weiler's, but Dimitri, of course, will immediately object that how can you impose an obligation from a polity who has less democratic credentials to the domestic ones, or a polity that is failing to comply with the democratic credentials. But this argument travels to another example that is not put in the same light. Think of the Charter of Fundamental Rights, the European Charter of Human Rights. It's basically ceteris paribus. I mean, I'm making a huge analogy, but the same case. A kind of supranational international order that is imposed on the national order with a court that adjudicates into that. And normally there is not a challenge on the legitimacy of that. Why? Because both the Charter of Fundamental Rights and also the requirement to respect rule of law are thought as restraints to political power. So there is one kind of the basis of the construction of European constitutionalism. Of course, the difference is that the Charter of Fundamental Rights, the Charter of Human Rights is much more precisely defined. With rule of law, we enter in all this kind of diffuse or difficult arena of how to define it, what are the components, how you know when it has breached, how much has it breached. So it's much more difficult to adjudicate, but basically they are part of the same kind of phenomenon. An instrument elaborated in the transnational and supranational level to contain the tensions and the temptation of domestic rulers to go too powerful. Right? Sorry for extending my response so much.
Thanks indeed, Carlos. Dimitri?
I agree with everything that Carlos has said, in fact, although my perspective for agreeing is a little bit different, of course. So what I will focus on is that different perspective, but in terms of the answers, my answers will be the same. So let's start with Francesco. I fully agree with Carlos for all the reasons he stated, but there is one reason that he hasn't mentioned, and we already had these conversations before. So it's like a repetition of a classic engagement among us, which is an honor to have, and that's the citizens' rights. Because every time when a member state leaves the Union, every single European citizen who is also a citizen of that state is betrayed. Among those who did not actually strongly support leaving the EU. And this is exactly why Brexit is a tragedy, because Brexit led to a situation where a book-friendly operation of a European democracy led to bringing millions and millions of Europeans down and stripping them of any rights for absolutely any rights in Europe, which is not nothing, for absolutely nothing in return. Because the nature of that polity hasn't changed. The UK functions as a democracy in exactly the same way as it used to function as part of the EU. Only every single Brit who hasn't yet procured another nationality is now a second-rate citizen in Europe, akin to Moroccans, to the Russians, to the Indians, etc. And this came at no benefit whatsoever for the UK as a country, which means that you simply betray all those who understand that they have rights, you flush them down the toilet of history in a way, and those rights will never be compensated, because it's highly unlikely that the EU will conclude any kind of deeper agreements in terms of personal rights with the UK than what we have now. So the UK will not be in at any point very soon a second Switzerland or a second Norway. And then if we approach the Poles and the Hungarians, many of whom are strongly opposed to the governments that they have, and that's precisely the tragedy, they sense that they live in an authoritarian state. So then, of course, we need to save the Union somehow from that authoritarianism. But if we simply kick them out, then we betray precisely those who are against what we are also against. And this creates a very, very problematic situation, because if you look at all the demonstrations against the current regime in Poland, whatever the issue, it can be like the integrity of the abusive laws against women and basic rights of women. It can be anything that goes against the basic rule of law and independence of judges. It can be against mingling with the very idea of having constitutional adjudication. There are always European flags, because there is hope that is connected to Europe, and then kicking them out will kill that hope. So it will turn Poland into new Belarus. And in fact, if you look at the economic indicators comparing Poland and Belarus right before the fall of the Berlin Wall, Belarus was a much more affluent and potentially successful society. Now it's radically different. Why? Because of the Polish foreign policy decision, basically, to join the EU. And joining Belarus is as easy in terms of being a loser state. Of course, the UK will never end up there, but the UK made a decision which is similar in terms of how far-reaching the implications are in stripping citizens of their rights. It's a tragedy, and we need to call it a tragedy. So if the UK is to blame, it's fine. But if the EU would be to blame for imposing this tragedy on Hungarians and the Poles, then it's probably not the union we would all like to live in. That's precisely why all those instruments that Carlos has described in such detail are of fundamental importance, at least symbolically, because the citizens constantly need to see European-level engagement with what they see themselves deprived of at the national level, with the deficient political system that oppresses them. And it's one of the important functions that Europe has to play. Coming to Adam, I don't believe that law is coercion. In fact, lawlessness is coercion. So the starting point of thinking about the rule of law is always restraint. And on this, the third question was precisely about restraint. So if we speak about coercion as the core meaning of law, then probably we absolutely disagree on what law is. Law is not necessarily abusive, but the essence of the rule of law is then to reach the position when politicians and whoever is acting in the state acts in accordance with the law, also means that the law is part of a larger culture of natural limitations on what whoever can afford themselves or their office to do or to perpetrate. And here democracy doesn't matter, because and in this sense the rule of law starts in England in the Middle Ages, when the idea was that the courts are kings, but the law is not necessarily king's law. Because a judge could rule based on general principles of equity, etc., against the king, or against what the law was understood to be as king's law. And this is what rule of law is about. Rule of law is about limiting power. So then, international law, whether international law can play that role of one of the tools to limit power, that's a big question. So I agree with Carlos on that. And if we want to turn to the literature, there is a wonderful article by Dworkin, one of the last ones that was published, where he, for the first time, considered that, in fact, yes, international law could supply counter arguments to absolute domination, legal domination in each particular legal system. So international, with its principles, it doesn't matter whether it's written, it doesn't matter how we call things. A constitution, a treaty, and a written constitution, the name tags are of zero importance. What is important is the conflict between what the sovereign wants to do, brandishing the will of the people, democratic power, absolute reliance on the military, whatever justifies power, and what he can't as a result of counterbalancing norms coming from anywhere. It can be your own constitution, like in Germany, where there are unchangeable parts of the constitution. No sovereign can change that. It can be international law, like the very basic principles on which all humanity agrees. If you overstep that, then a special international tribunal will be created, and you will be proclaimed a perpetrator of crimes against humanity. or it can be national understanding or subnational understandings. It can be even tribal sovereignty. It can be so anything that limits power and that is effective in limiting power is playing a fundamental role in bringing about the rule of law. And this is exactly why the EU is facing a problem, because the Court of Justice is not giving us clear signs that it would recognize strong limitations on power. So I agree with Montero. Tarico is a great example, but we don't need one example, and this is my problem with the whole legal system. We need a consistent application of this vision of the rule of law. So Tarico is always cited, especially in Italy, because this is something that can justify potentially a perspective that the European Union is a system of law which is based on the rule of law. But there are hundreds of thousands of other cases which are not cited, and not so much can be derived from one case, this one successful case. So in fact, I think it's an example which testifies against itself rather than for. And in terms of pointing to something which is more significant, I would probably suggest opinion 213. And especially, I've been browsing through old notes. I found a paragraph in opinion 213, paragraph 184, where the court says basically, if structurally I'm not an absolute sovereign, then we don't need human rights. And this is something that no constitutional court should ever say. And it shows that the Court of Justice is far removed from Bundesverfassungsgericht, from Corte Costituzionale, from any respected constitutional court. And then I was looking through the jurisprudence of the Russian Constitutional Court, and it has an identical paragraph. There is an identical paragraph, I mean, almost word by word, it's decision number 21P, where the court says, actually, we're not always bound by what the CHR says. There is one fundamental difference between these two courts. One is actually a constitutional court of a constitutional system that is part of the ECHR, formally making part of the system, and another, and using this argument in order to deviate. And another one is a constitutional court of a system which is not based as to the letter of its own treaties on the same principles necessarily, because supremacy and direct effect come first, and it uses the same argument in order precisely not to join the system, to get rid of any kind of constraints. And this is, I think, is a big problem. And then if we move on to the last questions, I think judicial restraints versus judicial activism, this is a difficult question, but Article 19 as it is deployed now is probably the most arch-important example of judicial activism we have ever seen coming from Kirchberg, coming from Luxembourg. So I think it's just settling down now. We don't have enough case law, although we have a good dozen of cases. And this realization will only come. That's why if you're interested in that perspective, look up my little paper, which is called "Rule of Law as a Tool to Claim Supremacy," and that's the successful perspective for the Court of Justice. It's a Reconnect working paper available on SSRN. And I think this is not how the rule of law should be used.
Wow, thanks indeed. Thanks indeed to our speakers and to our students. Our long day has come to an end, so I want to thank again Carlos and Dimitri for their fantastic and very rich presentations. And final message for our students. We'll see you tomorrow as always from 9. Thank you very much, and see you soon. Bye-bye. Thanks, Carlos. Thanks, Dimitri.
Thank you. Thank you, guys.
Thank you. It was